Hello everyone, this is Steve Yoder. Welcome to week 9 in Legal Studies 246, the legal environment of business, here in the fall of 2016 at the UAB Collat School of Business. This week we are continuing our look at the law of contracts. In the last learning module, we started our look at how contracts are formed. We will continue that, and we will then go on to how contracts are performed and what happens when they are not performed. What does one side seek from the other, perhaps, when there has been a breach of a contract? As usual, you can see here that there are 2 chapters of the textbook that cover contract law other than the law of the sale of goods, which we will be talking about next week. There are some narrated slides for both the second half of Chapter 12 as well as for Chapter 13, and there is a quiz that is due on November 4, which is not a Sunday night. That is the same day that our next exam will become due. Here is a quick recap on what we covered in the last learning module on contracts. Our goal is to have a valid contract that would be enforced by a court. We want to avoid void contracts, and we want voidable contracts to become valid. Checklists we've talked about before. Here's our checklist that we would use for the formation of a contract. We've already talked about the first 3 elements on this checklist: agreement, consideration, and capacity to enter into a contract. In this learning module, we will be looking at legality, and we will also be looking at whether or not there might be some defenses that have been recognized that might allow one party to be excused from a contract. A contract must be for a legal purpose. If it is for an illegal purpose, it will be void. One of the primary arguments, primary defenses that is sometimes used when someone is trying to get out of a contract is that there's been a mistake. The law divides mistakes into 2 categories: unilateral mistakes, and says that you cannot get out of the contract for a mistake by just one party. There are some exceptions to that. Here is an example of a unilateral mistake in the news that was such an exception. The law also has a category of mistake called mutual mistakes, and here the rule is that the contract is set aside if there has been a mutual mistake. There are a number of defenses that you might try to use if there has been a contract formed, and we will be covering several of these in depth. Once a contract has been formed, the question sometimes arises is whether a third party can get rights under that contract, a third party who never actually signed the contract. Chapter 13 covers that topic, and we will be looking at this topic as well this week. Whether or not a contract has been performed is often the subject of litigation, and a key word here is whether the contract can properly be discharged. In this case, the word discharged is a good thing. You want to say that a contract is being discharged because that means it has been fully performed and you can go on to your next contract. If a contract has not been performed, the question of damages might arise. Damages is a very specific term that refers, as we will see, to money. Sometimes the remedy is not money, however, but rather something called specific performance, and we will be talking about that. Here is a sneak peek at a question in the question pool for the second exam. Look hard at this, look hard at page 321, because that question might be on your exam. Finally, take a look at the Canvas calendar for the next couple of weeks. On Sunday night, November 30, there are quizzes from Module 8, and then note that there are a large number of things due on Friday, November 4. That is the date that the second exam will close. those. It will open the day before that, and in particular, look at the quizzes all due that day. They are not due on a Sunday night as is usually the case. They are due on Friday night, November 4, the same time that the module 7 through 10 exam is due.